Okay, I will go ahead and get started, you guys, because I want to honor your hour. I know that everyone is really, really busy, and I appreciate you guys taking the time to be here. We do these quite regularly, but I'm actually really excited about this one because this one is for the VOE PTA, which I am biased about and unabashedly support. We are a VOE family too. I have a daughter in second grade and a daughter in kinder, and so this is really exciting that we have the chance to be able to do this. This is a Spirit Night fundraiser, so for everyone who dialed on, we'll donate $20 to the PTA per head. And then on top of that, I just hope that you guys get something out of it by way of just education and learning about things that you can do for you and your families. Okay. Here we go. Okay, so real quick, to introduce myself, my name is Artie, and like I said, I'm a VOE parent, like all of you guys on the call. I went to Stratford High School. I have lived in Houston since I was 8, so my folks still live in our Stratford home right by City Center. Went to A&M, went to SMU after that. I've been practicing for 17 years. For a large portion of that, I was an attorney. I was a partner at a larger boutique firm. So I decided that I just I wanted to practice law a little bit differently. I felt like we were, as legal educators, just kind of dropping the ball and not really providing the kind of education we need to on just important legal concepts. You know, for example, estate planning, right, can sound really intimidating, really overwhelming. It's something that affects every family in America, but it just really seemed like it was something that wasn't very well understood. And so AB Law, our model is to be very education driven, because I really believe that people make better choices when we know what our options are. So we've actually started doing a lot of these around town. Again, today is to benefit the VOE PTA, but if you are a part of another organization like a church group or a parent group or a work group that would be interested in bringing this to you guys and raising some funds, I am more than happy to do it because I really enjoy the education piece of all of this. Today is called the Empowered Parent, right? So we're going to talk about estate planning and how estate planning specifically impacts and relates to the parenthood journey. So there's two really big pieces of that. There's the how do we get our dollars to our kids, and how do we get the bulk of those dollars to our kids, right? How do we make sure they go to our kids and they don't inadvertently go to other parties? So there's that piece. Then a really, really big piece, which is probably on a lot of your minds, is how do we choose the right guardians, right? How do we, after we are gone, worst case scenario, how do we make sure our kids are accounted for, they're in the right homes, with our money to protect them, and they're just safe and well cared for. So we're going to talk about all of that, and then there's some other really cool aspects we can talk about, such as asset protection and wealth generation, all that. But today we're really going to be focusing on just like the main core concepts, and we can get into some of the other stuff later. Specifically, some of the things we're going to talk about today: wills versus trusts. You guys have probably heard these terms tossed around. You'll hear about wills a lot colloquially, right? Everyone will talk about you need a will, got to get a will. We'll talk about the difference between the two. What's right for you? What makes sense? What does each one lead to? What does a will mean? What does a trust mean? What is, how do those play out long term? We'll talk about your legal rights. And you know, the thing is, a lot of people will say, I don't have a plan. Well, the truth is that even if you don't actually have a plan, the state of Texas has a plan for you. I want to talk about what that looks like. There's the status quo, the plan that Texas has for you and for your assets and for your kids, actually, like where your kids go. So we'll talk about all of that, because I'm a big believer in knowing your rights and knowing the law and knowing how to make the system work for you. I think, again, the more that we know, the better positioned we are to make proactive choices that make sense for us and our families. And that's the education piece, right? So we'll be talking about that today. Those are the important pieces, right? Those are the core pieces. But then there's also these pieces of how do we minimize estate and capital gains taxes? Let's be legally savvy and financially smart. There's a lot of really cool strategic tax stuff that we can do. And then there's, you know, maximizing asset protection. That's important. So a lot of today is going to be talking about just things that are, you know, very important in the estate planning world, but also, you know, we don't know what we don't know. So things that are unique to parents and the parent journey. And someone here I saw asked me, and by the way, you guys are welcome to chat with me through the Q&A at any point. So I'm happy to answer questions along the way. This is meant to be informal. It can be interactive. At the end, we'll definitely have question and answer. So I have a question here about, will the slide presentation be available later? Absolutely. I will absolutely share that. So yes, this will be available later. Okay, what is estate planning? You know, again, estate planning can sound vague and murky and ambiguous and scary. I like to think of it as a plan for life. I like to think of it as being in control, making choices that intentionally work in favor of your family and taking care of your people, right? Taking care of your kids, taking care of your assets, planning for them and leaving an intentional legacy. Again, we'll expand more on that as we go through the process today. Okay, so when we think about estate planning, a good estate plan should really account for 4 pieces. Okay, a good estate plan should account for your assets. Those are your dollars. Where do those go? How do we protect those? Your family, right? The kids, your little people, who's going to take care of them? How do we make sure they're protected for? There's a piece of this about you too, your comfort, right? You know, through the pandemic, we have seen how the health journey can really play out. How do we, you know, make the right kinds of choices for end of life stuff, right? Power of attorney stuff, living will, life support, organ donation, that kind of stuff. So we'll talk about that. And if you happen to be a business owner, that's a really important piece too. If you are a business owner, then chances are a lot of your dollars are tied up in your business. And if we haven't accounted for that as a part of your estate plan, we don't want it to be a fire sale. We don't want it to be a distress sale at the end, because we really want to preserve those dollars to make sure that they rightfully and properly pass on to your family members. So that's also an important piece of it. Okay, so like I said earlier, even if you think you don't have a plan, Texas has a plan for you. And we're going to talk about what that status quo is. Something I just want to mention before we really start getting into the substantive stuff here is my goal today is not to motivate by fear, and it is not to incite fear in any way. The goal today really is to just let you know how things naturally play out. And I absolutely want to make very clear that we have tools and solutions for everything. So everything we're going to talk about your dollars, about your kids, about you, there's solutions and tools for everything. But if there's one thing you take away from today, it's that estate planning requires some intentional, proactive action on your part, because Texas has a plan for you, and it's not necessarily always the best plan or the one that really favors families and their assets. Okay, so colloquially, you have heard about a will. If you have a will, so you may not have anything right now, so you may not have a will, or you may have a simple will. Okay, so regardless of whether you have no will or even if you have a will, the default is that your family will have to go through a court probate process. Okay, what is a court probate process? A court probate process is how your will is administered and how your assets are distributed. There are 2 big primary reasons for a court probate process. The very first is to put creditors on notice. Okay, a lot of Americans have debt, and because of the design of this as a blanket process, it is very public. There's a publication notice that's in the paper, and we notify we as probate attorneys notify everyone across the board. Hey, this person has died. This person has passed away. If you think that you have a stake in this person's estate, here's your chance. Come get your bite of the apple. And creditors get the first bite of the apple often, right? So by nature of that, by the design of that, probate is a public process. All of your assets are public. So every dollar you owe or every dollar you own in the amount that you own, who you're giving it to, when your children are getting it, all of that is completely public. It is an airing of your financial laundry, essentially. Also, because the creditors get the first bite of the apple, your assets are frozen in the probate process. Okay, so if you have young children, a lot of families don't love this. They don't love the idea of this airing of your financial laundry and everything being public and everything being frozen because creditors have to get the first bite. It is very heavily controlled through a court and a judge process. You have to have an attorney on board. It is often very, very drawn out. So it can get very expensive. And most people who've gone through this process will tell you that it is exhausting and one that they did not enjoy. You'll see this spaghetti stripe, and I won't like highlight all of it, but basically the way it works is you have to put everyone on notice. You have to basically collect all the assets. You have to see if there's creditors. You have to sell the assets. Again, all of this is done with a lawyer by your side and then the judge. And then a large part of the probate process is about retitling those assets, right? So right now they're in your name, and through the judge and the court and a lawyer by your side, you're retitling these assets into the name of your children. And what that distribution is. And again, we're just not allowed to seal the process and make it private because it has to basically be a fair opportunity for creditors to be able to see what is available. So that's the nature of the court probate process. Real quick, just in summary, your private matters become public. They are very easy to contest. So if you are concerned about there being a challenge to your guardianship nominations or a challenge to your division of assets, because this is already in a court and everyone has an opportunity to be heard, this is where we start seeing a lot of the conflict or the potential for conflict coming in. Courts are involved. There's no distribution, so assets are frozen until the judge orders it. Attorney fees and court costs add up here. If you happen to have homes in more than one state or property in more than one state, if you have a home in Colorado or a condo in Florida or anything of that sort, you have to have two separate court probate processes, right? So this can get a little involved and a little murky and tenuous, and honestly, it's just not fun. And this is just the default. How do kids inherit with a will? So kids in our judicial system cannot inherit money. The way that until a child turns 18, they cannot inherit money. So there's a judge that will appoint a financial guardian to guard over those assets. Those financial guardians are usually paid for their time. Who will the judge choose as a financial guardian? We don't know. It could be a family member. It could be someone we don't know. Okay, so the status quo here it kind of takes a lot of our control away from us, right? There's a lot of pieces that we just don't know here. And then how does it typically work? Once the distribution of assets are kind of done, and we figure out how much of your pot is going to be divided in twos or threes, depending on how many children you have. They receive the money outright without any protections or guidance at the age of 18. So if you happen to have, just making up numbers here, a $10 million estate at the time of your death, and if you had minor children, then as soon as they turn 18, they get $5 million in their bank account outright, right? A lot of parents don't love that because that's a lot of money just to receive outright. Okay, so that's kind of what the probate process looks like. And by the way, if you guys have questions at any point, just throw them in the Q&A and I'm happy to answer them. Something important to just be aware of here is, unsurprisingly, a lot of us don't know what our families own, right? Like if I hadn't done this for my parents, I would have no idea what they own. I would have no idea that they have random CDs in some locations and safety deposit box in others, and annuities or life insurance in other places. And so a real problem in estate planning is just not knowing what our families own. The default there is that assets go to the Texas Department of Unclaimed Property. And that pot of money is already $6 billion. We usually, when we identify problems at our firm, we try to create solutions for them. One of the things we've done for this one is we now have pretty comprehensive, robust asset inventories that we keep electronically, and we continue to update because strong believer, and if these dollars are yours, keep the dollars for your family. But this is an important piece to know. Okay, like I said, the goal here is just to know what the status quo is and how that works. But there are solutions, and so the good news is there's solutions for everything. We just have to know them and we have to act on them. So something that has become a lot more mainstream now these days, especially with younger families, I'll tell you about 90% of my younger families go this route, is the route of a living trust. Okay, what is a living trust? A trust is essentially a will substitute. It is a legal vehicle, and actually a very clever legal vehicle, that is designed to avoid probate. If you don't want your stuff to be public, if you don't want to go through the court probate process, if you don't want to tie your funds up, if you don't want your assets frozen, living trust is a very, very viable option. And if you'll remember what that spaghetti looked like before for the probate process, The trust process is actually very clean, very streamlined, and very immediate. It just requires notice to the beneficiary, sale of the assets, and then distribution to the beneficiaries. How does the trust work? The trust, like I said, it is very much a legal vehicle. It is a legal tool. The way that we use it is we essentially create a bucket, and you will be 100% owner of your trust, but we take your assets and we put them into the trust. Okay, so we will actually deed your home into the trust. Retirement accounts and life insurance, the beneficiaries become the trust. We'll move bank accounts over to the trust. There's a few things that we do now to essentially have your trust be comprehensive and a consolidation mechanism for all of your assets. Once that is done and all of your assets are retitled into the trust, there's a trust document. And that trust document dictates how those assets are going to be distributed. No one ever sees the trust document. The trust document is absolutely private. So if you remember, I said maybe just a few minutes ago, the probate process, one of the primary reasons is to retitle assets. If we get ahead of things now and we retitle the assets now, we've completely carved the court out of the process. So we've retitled all the assets, we put them in this trust, and then when you pass, the assets automatically will be dictated by the trust document and go down to the parties who you wish for them to go to, privately, seamlessly, immediately, right? So you've retained privacy and control and flexibility. A lot of people will ask me, well, what's the downside to a trust? The one thing I will say about trusts is there is a little bit more work now than there is with the will, right? So, but I also like to say that there's nothing that we do now with the trusts that your family wouldn't do later through the probate process when they have to retitle your assets. So what you would do now is what your family would have to do regardless later. We essentially retitle those assets now, put them in the trust. Something I also like to make very, very clear is that the trust is tied to your social security numbers during the course of your life. So it is a see-through or a pass-through. What I mean by that is there's no additional financial implications or no additional tax implications. So you would do your taxes the exact same way. Everything you interact with your assets the exact same way that you do now. You're just saving your family the hassle of going through a longer court probate process. There's the privacy, so no one ever sees how much money you have. It just doesn't have to go through the courts. And because we don't have to go through the courts and because we don't have to cater to creditors, we now have been able to retain the privacy, the seamless flow of money, bypass the court's involvement. The trusts are actually the cheaper option because it's a one-time investment rather than the probate process where you have to pay for the will. And then after that, you have to pay for the actual court probate process. And that can get a little unwieldy and long, and they can get very expensive very fast. There's some cool stuff that we can again do with the trust. For example, asset protection. This is something that a lot of folks don't think about, but if we're all relatively young at this point in our lives, right? Like in our 40s or our 50s, some of us might be in our 30s. If assuming you are married, if our spouse passes away and we were to get remarried at this point, what a lot of people don't realize is if there is a second remarriage and you predecease spouse number 2, unintentionally, you can actually carve out your kids from your entire inheritance, because that's how assets work in a marriage. Assets get commingled. Again, this is a lot of like things that you just don't think about, or we don't know what we don't know. So your spouse passes away, you happen to get remarried, or vice versa, right? You pass away, your spouse gets remarried. They predecease spouse number 2. The assets can then go to that second spouse, the second spouse's children, and our kids get carved out. Again, all unintentionally, but it can happen. So there's a lot of really ironclad asset protection that we can do. We can protect against lawsuits and creditors and remarriages and so on and so forth. If our kids get married and our kids get divorced, there's ways to protect against that, make sure our kids don't lose half of the inheritance through a divorce. Lots of cool stuff that we can do with capital gains, tax minimization, estate tax minimization. So the trust gives us a lot of options, a lot of flexibility, and a lot of control in that sense. I have one other question here. Okay, yeah, that's a really good question. So the question I got is, if a creditor doesn't have the view of trust, what's the potential for creditor's claims to be satisfied? The answer there is, if we're not broadcasting it, it doesn't happen at any point. There are statutes of limitations So if someone were to pass away and the assets all get distributed, it's done. It's out of your estate at that point, right? The transfer has already happened. So it's a pretty great tool to just bypass a lot of the creditors and so on and so forth. Okay, so we have now talked about, I think, in the level of detail that we need to, how assets can pass, right? So we've talked about the probate process, wills, we've talked about trusts as a tool. The next thing we're going to talk about is guardianship. Okay, so I know that's why a lot of us are on this call, because the guardianship piece is important to all of us, right? We all have minor children. Again, this piece can get a little bit heavy. I again really just want to reemphasize that we have solutions for everything here. So I know that, I think there might be one more question. Yeah, I'll respond. There's a couple of questions coming in here about creditors, but yes, the answer is yes. So creditors aren't put on notice the same way through a trust that they are through the probate process. So yes, they essentially can move to the back. Okay, let's now transition from the asset piece to the guardian piece. I know that the reason that a lot of people don't do estate planning is because this piece is a really hard piece to think about. The guardianship stuff, I absolutely get it. And I absolutely know that this piece can be gut wrenching, because as parents, we struggle with this, right? We absolutely believe that no one is going to be as good of a fit for our kids as we are, right? No one seems like a perfect fit, right? What I like to say here, while I absolutely agree with all of that, and I feel the same way about my family, and this was probably the hardest part of my estate plan too. What I like to say here is that we are still, no matter what our options are, we are still better positioned to make these choices than a judge would be for us. Because if we don't make these choices, a judge makes them without the same context that we have. A judge doesn't understand what our relationships with our siblings may be, what interactions between cousins might be, certain family members that we may not want our children to be about, right? So we're still better off making these decisions rather than someone else making them for us. So again, I know this is a hard decision to make for a lot of reasons, and I know that it's actually a very hard decision to make between, like if you're married, between spouses, right? Because one spouse may feel very strongly for certain people in their family or certain friends, another spouse might feel the other way. So we've actually developed a process at our firm, which I think actually has worked really well, where we can take couples down an exercise to help them focus. Each couple, each spouse does it individually. And we can reach a process together of who would be the best fit for this role. I like to tell folks, I like to remind folks that we should not pick guardians based on financial means, because the money that you have is going to travel with your kids. So sometimes clients will say to me, well, there's a family member in California or a family member in New York, but they just don't have the space, right? Those things can be solved for. Your dollars can hire extra help, whether it's au pairs or nannies or getting a larger home. Those things can all be solved for. Things that I think that are pretty important to consider is trying to find someone who is aligned with you when it comes to values and visions, similar ideologies. Those are really the kinds of things we want to focus on when we're thinking about guardians. Sometimes that's a family member, sometimes that's not. Sometimes it might be really important for us to want our kids to stay in Houston, in the community that they know and they love. Depending on who the guardians are, we may be able, if they don't have, if they're not strongly tied to their communities, we can make the ask that they come to Houston, that they live in our homes or live in our communities. We can provide them stipends. There's just a lot of stuff we can do here to try to make scenarios work where there's room to perhaps allow for them to work or create opportunities. But again, I know this part is challenging. And so we go through this all the time with clients and really just kind of help them hone in on people. Again, the choices that we make are better than the choices that a judge can make for us. And something else we do at our firm that's actually unique to our firm, this is completely optional, there's nothing legal about this, but we do legacy interviews, and those can be fun and lighthearted. They're for our families, nice keepsakes, and they can be, cute stories about how you met or funny memories from your childhood, but they can also be messages to guardians about things that are important to you. We have worksheets for guardians, like instructions for guardians. So if having your kid be a part of a certain church, or if there's just things that are really important for preservation of your values and how you want your kids raised, we absolutely have the tools to try to pass those messages on, whether they're recorded or instructions. If there's a dollar barrier, we not only can send pots of money with your children, but also we can provide stipends for the guardians. There's just a lot of different ways we can try to create answers or solutions here in what would otherwise be a pretty difficult time. This goes back to the status quo. I don't by any means intend for this to raise alarm, but this I think is really, really important for us to understand. If we don't designate guardians, the default is foster care. And every time I say that, I still get chills. And I kind of want to say that again, because it's just really important to sink in. If we don't designate guardians, the default is foster care for our children, which is why this is so incredibly important. And if you think about it, it makes sense. Again, I think one way to think about this, for example, is you got in a car accident. Husband and wife both got in a car accident. First responders come out. They are not going to be equipped at that point or take on, even try to tackle the decision of where your children should go. They have no idea what family dynamics are like, who may or may not be a safe option. And so the default is foster care until a judge can find space on their calendar and there is a hearing and the evidence is heard, witnesses come in, and a whole process has gone through to figure out who should then become the guardians. Okay, so this is just really, really important. The asset piece is really important. This piece is equally, if not more important. We've got to work, we've got to do the hard stuff to figure out where our kids are going to go. Something that is really unique to our firm, and this is again something that we designed because we saw the hole in the system. People will talk about guardians, they'll talk about long-term guardians all the time, right? Where do you want your kids to go? Well, here's the thing. If your long-term guardian happens to live further away, right? California, New York, even Dallas or Lubbock or elsewhere, right? In the time between when they can come down, those guardians can come down, which may be a day or 2 days or 3 days, or even, maybe the next day. In that period of time, the default is still foster care. Because again, first responders are not going to make the decision for where to send your children. So something we do at our firm is we do short-term guardians and long-term guardians, okay? Short-term or emergency guardians are people that live in our communities, 30 minutes from us. It can be neighbors, school teachers, people at our church. It can be whoever we want it to be. But what we do is we essentially create wallet cards. And the wallet cards will have the short-term guardians' names and information on it. That's really important because first responders are trained to check the wallets. And so we do full designations and appointments of these short-term guardians. Those people are called in an emergency. They essentially take possession of your children lawfully and correctly until long-term guardians can arrive. And then everything goes from there. I think this piece is really important because obviously this is something we want to take care of, right? We want to take care of this for our kids. We want to make sure it's just handled, right? And that there's not any holes in the system there to allow these unintentional things to happen. Oh, I have one more question. Okay. Good question. Someone asked me, how does guardianship work if the guardians live abroad? Absolutely. We have a lot of clients that have guardians that live abroad. That is a conversation that I think is very fact specific. If guardians live abroad and have the capacity to move here and live here in your home, that's one scenario we can account for with stipends and so on and so forth. A guardian will have to be able to come into the country. So we will have to make sure that they at least have the adequate kinds of visas to be able to come in. That's going to be pretty close to non-negotiable, but for everything we do, we always have our first option, and we have 2 or 3 backups because we absolutely just do not know how life is going to play out. And so those backups are really, really important. There are scenarios where, that can go many ways, right? We can have a guardian come to America and live in our homes and take care of our children. Or it may be a scenario where your wish is that you want your children to go there. Both can be done. Both can be done. We just have to make sure that the scenario is going to be supported, and something that if the child is going to leave the country, we absolutely have to make sure that we can prove that that is in the best interest of the child. Okay. A lot, again, at the end, we'll definitely have question and answers, but I know this is a big and heavy piece. And so if there are more questions around this, I am happy to answer them. Okay, so kind of like I was telling you a little bit earlier at the beginning, there's a couple of different sides of the coin when it comes to estate planning. There's the asset piece, there's the kids piece, right? The family piece. And while most of it is about other family members, there's still a piece about you, right? And getting documents in place that are important for you. So we do these with all of our plans. There is a financial power of attorney. If you are in a situation of if you're in a coma, you're incapacitated, who do you trust to reach into your bank accounts and be able to pay your bills, to keep your lights on, keep your mortgage going? Who do you trust with your dollars? That's your financial power of attorney. There's your healthcare power of attorney. That person is the person that speaks at your bedside. Worst case scenario, right? The person that is speaking for you, that is interacting with your doctors. We also create HIPAA waivers to make sure they can get access to all of your medical documents. And then there's the health directive or the living will. This is the piece where you make your wishes heard. How do you feel about life support? Do you want it? Do you not want it? Do you want it to be time boxed? Is it going to be based upon a doctor's or 2 doctors' opinion of you're going to be in a persistent vegetative state or with significant brain damage? There's so many little pieces here. And these pieces are important because they allow you to stay in control at a time where you really don't have any control, right? When you were incapacitated. So we absolutely have to make sure all those ancillary documents are taken care of. We want our powers of attorney to work when we need them to. And the living will, I mean, I think most of us on this call are probably old enough to remember the Terry Schiavo case. This is why living wills are so important, because we want our wishes to be preserved. So those are important pieces of the puzzle. Okay, so we're going to kind of touch on the highlights now of things that we talked about today. One of the first big highlights, our children are important assets of ours. We need to figure out, it's important. Again, this is one of those things where it's important to be proactive and intentional. We need to think about who good long-term guardian fits are and who good short-term guardian fits are. Again, short-term guardian fits are, again, people who are going to be in your community, right? Within 30 minutes of you, who can just kind of bypass that foster care bit until your long-term guardians can arrive. I know how painful it can be to think about long-term guardians. So we have an exercise to help you kind of get to the bottom of that. But something else we do at our firm is we are reviewing and updating our plans. We do these complimentary 3-year check-ins. And so, for example, I can tell you guys that, my parents are in their 70s, but they live, 3 or 4 exits down from me. And so right now, my parents who are in their 70s are my long-term guardians, right? In about 5 years, they probably won't be my long-term guardians anymore. But because we continue to check in on the plans, if it's easier to think about this in smaller digestible pieces, we can do that. We have the luxury to do that. If it's just too overwhelming to think about who is this person going to be for the rest of our lives, we can think about, well, who's the right answer for the next 3 years? And then when we get to that 3-year mark, well, do we need to revisit it? And at the 6-year mark, do we need to change it, or are we still good, right? And so again, if that just makes it easier to process, then we're in a much better place than not having anything in place at all. Okay, lesson number 2 goes back to the asset piece that we were talking about at the beginning. Again, wills versus trusts and how they work. You know, a lot of people, a lot of families have really kind of shied away or walked away from the probate process because it is public, it is drawn out, you lose a lot of control, your family, the assets get tied up in the court system, and it can get really expensive really fast. Living trusts have really become the new norm for families. And again, there's just a lot that you can do with the trust as a tool and being able to get that money immediately. Lesson number 3. This is kind of where it's important to really just think about how comprehensive you're being with your planning. You want to account and make sure you're capturing for all of your assets, right? We talked about just a few minutes ago about the Texas Department of Unclaimed Property. How do we make sure we keep those dollars and they're not going to the state? So something we do at our firm is we create a robust, like I said, asset inventory, and we make sure we capture those and we continue to capture those. It stays electronic and it's dynamic. We make sure that we have a grip on what those assets are at all times so that it's easy for our families. We should have a plan that accounts for the growth of assets or life changes. Like I said, we're checking in every 3 years to make sure that the plan is actually working when we need it to work. I expect that for a lot of people on this call, if we don't already have an estate tax issue, we may have an estate tax issue soon. And by soon, I mean at some point in our lifetime, right? So it might be 10 years from now, it might be 5 years, 10 years, 15, 20 years from now. I usually have a pretty good sense of when I'm looking at a family's assets of what that growth trajectory will look like. A lot of people don't realize in America, and we didn't really talk about this a bunch today, but it's worth mentioning. America has something called an estate tax. And that estate tax, well, so it changes with every presidential administration. But right now, we're still under the numbers through the Trump administration. They are the highest they've ever historically been. We know with absolute certainty that they are going to come down to the numbers that they have usually been at in the next 2 years. We know that's going to happen. So we know it's going to be about 5 to 6 million a person. Okay, that sounds high, but it is not calculated like net worth. It's calculated by taking the full value of your home without a mortgage note tied to it. So if you live in a home that's $1 million, it's $1 million, not a million minus the 700 note on it, right? If you have $1 or $2 million worth of life insurance, that is counted in full. If you have a retirement account that maybe has $1 million in it, that is counted in full. And that doesn't, we haven't even brought in bank accounts and other things, right? So you can see how you very quickly, and it might not be now, but how you could very quickly get to that $5 million piece, right? And how it could happen during the course of your lifetime. You absolutely need a plan that's going to be able to account for that kind of growth and for just life changes in general. And then if there's, you know, the piece where you want to build in some additional asset protection to make sure things don't get lost in a remarriage or in a really ugly car accident or a lawsuit, or to creditors. If you want to protect against all of those things, including question on creditors that we've been talking about a bit today, there's ways to be able to do that and also minimize taxes. The biggest takeaway today, guys, the biggest takeaway is that estate planning requires intentional action. We've talked about how what the state of Texas's plan is and what the status quo is for your assets and for your kids. And here, planning really allows you to kind of stay in control and make decisions that make sense. And honestly, they're just, you save a lot of money in the process. The state of Texas's plan is not ideal for most families. Okay, so this next piece, I didn't used to include this, but I would get so many questions because I can appreciate that a lot of families have not ever worked with a law firm. So I will go through this piece if some of you on the call are like, hey, we just really need to do something, like it's time to do something. I'll run through this piece and then, you know, just leave you with it. So like I said, we designed our firm a little bit differently. Everything we do is flat fee. We custom design everything we do, and we do stay on for the long term. Our goal is not to just hand you a stack of documents. Our goal is to make sure those documents work when we actually need them to work. We're checking in every 3 years. We're doing those complimentary 3-year check-ins. We send letters to everybody that you name in your plan so that they have our contact information. We have that helps us avoid the case of the missing documents, because many times you'll hear about that missing document. We make sure that that never happens. And we make sure that your family really knows how to get the process started, because it can be overwhelming and you don't know what you don't know. So we can get the process started and steered in the right direction for you guys. make sure they have all the assets, and really just get things flying and help out kind of where we need to help out. And because we know families have a lot going on, we can take care of most of this from your home. We can send notaries to your home. You never really have to leave your house to get any of this done. So again, if you're on this call and you're thinking, hey, I really just need to do something, the first step would be, well, I don't charge for any of my consultations, so I am more than happy to talk to any of you on this call. If you would like to talk, well, two things. Actually, at the beginning of this, I had dropped a link in the chat that was like an evaluation worksheet. So if you could just fill that out and submit it, that would help us really kind of target, make sure that we are providing the right kind of education for the communities that we're serving, because we obviously want the education to help. So if you could submit that worksheet, that would be great. Even on that worksheet, if you want to talk to us about anything, you are allowed to ask me any questions, and I mean that. That would be a good place to do that. Or you can drop it in the question and answer and just say, hey, I really have some questions I'd really like to talk. But yeah, we don't charge for any of our consultations. So happy to have some short casual calls. Or if you guys are like, hey, we really want to do this and we really want to jump in full transparency on our pricing, we have wills packages and trust packages. Our wills packages start in the 2000s. Our trust packages start in the 4000s. That includes obviously the documents, so the will documents, the trust documents, and then it includes all your power of attorney documents that we talked about. It includes all the guardianship stuff we talked about, the short-term, the long-term, includes those asset inventories, the complimentary 3-year check-ins, the letters to your family, the video legacy interviews. We just include all of that, and it's very comprehensive, but it's because, again, over the course of time, we have identified where all the holes in the system are, and we really try to plug those and account for those. As far as our trust planning goes, average fees start in the 4000s. If you want to do a lot of advanced tax planning and advanced asset protection, it can go up to the 8000s. That is 100% on you. I lay out options, you choose. I don't like to talk people into anything. I want to make sure that you're picking something that makes sense for you and your family. I also don't offer anything at the firm that I don't think is going to save you hundreds and thousands of dollars. Everything that we offer is going to save you guys a ton of money in the long run. I want to make sure it's the right size solution. It's not going to be the kitchen sink thrown at you. And really, it is a one-time defined cost. So again, the value of planning is actually a huge cost savings, and you just kind of stay in control of it. And with all of our plans, with a will or a trust plan, the guardianship piece is obviously very, very important. So you will get all those guardianship documents, the emergency guardianship documents. You'll get the wallet cards for first responders, so we know the right people are getting the calls. And we actually put together powers of attorney for your minor children, because if you are unavailable, we will make sure that your minor children can get the health care, that the medical attention that they need. And I just throw this out there. So if someone is like on this call is like, hey, it's time for us to plan, we need to plan. I will offer a $300 discount for anyone that wants to plan off after this call. You just have to book a session by the 25th of May. So that's the last day of VOE, as if you didn't have enough on your plate. But anyways, we're booking for July, August, September. It doesn't matter when we have this session. This just is a way to kind of say, hey, we're actually going to do this. We're going to move forward. We're going to do this for our family. And I'm happy to offer that discount. But like I said, we don't charge for our consultations. So the way that our process works is I'm always happy to answer any questions, but we do complimentary review and design sessions. So you would fill out a worksheet with your family profile and your asset profile. I do about 2 hours of homework before we ever jump on a call or a Zoom session. And I can see that I take all that information and can make options and recommendations that are targeted towards you and your family and what makes the most sense for you guys. So again, everything is super custom, what makes sense for you in your specific scenario. And then if you guys are like, yep, we actually want to do this, that's when we start talking about the fee structure. We don't charge for any of the education that we do, whether it's webinars like this or estate planning review, because again, I just think there's so much value in that. So, okay, so we are actually done for now, but if anything I said today resonated, wants you to want more information, makes you think that, hey, this is something we just really need to do, please feel free to reach out. There's lots of ways to reach me here. You can book a call automatically through my Calendly if you want. There's a ton of options, a ton of ways to reach me. Again, no pressure on this piece at all. This really was intended to be a PTA fundraiser, and it very much is. But if it makes sense, if you just really want to plan, happy